All right, you guys, welcome. Welcome to today's podcast. We're going to talk about trusts. We're going to talk about equity trusts, and we're going to talk about common law trusts. So as soon as I get a final thing here open, we will get things started. There we go. And all right, cool. I hope everybody's doing great today. What is today? Today's June the 17th, man. It's like, where's this year gone? I don't even know. I don't keep track of time. I was telling somebody today that, well, they shouldn't even keep time. Like, time shouldn't be a thing. We just shouldn't have to worry about it. It shouldn't exist. So anyway, let me get the PowerPoint. I just literally finished this, guys. I was having some technical difficulties. And I'm going to go, today's presentation is between common law and equitable trusts. And I just need to get the PowerPoint up for you guys, and then I can present it. So let's see. How do I present? I know I can do this. Slides. I can do your computer. Okay. Upload a file. I can do that. Right here. So this is what I'm trying to upload. So it says it's uploading right now. I guess we just wait, hang loose. I'm going to have cheers to everybody. I'm having some tea. And by the way, I wanted to thank one of my members, Whitney, sent me a really awesome, I don't have it right here, but sent me a really awesome mug with wolves on it. It's cool. And so thank you, Whitney. I appreciate you very much. This thing is still uploading, guys. So I'm just going to kind of give you guys a little bit of like what we're going to be getting into and what we're going to be doing as far as the trust stuff. Because there's a big misconception, and I didn't quite understand it either until after I got into this much deeper a couple of years ago. And because I always thought that things were just a certain way, and, well, that's just the way it worked. And no, there's different levels to different things. And one of the different levels that we're talking about going to is a level on privacy. Okay, so we're stepping up the levels of privacy for one to walk into shoes where I think something just dinged on me. Not dinged on me, but dinged on this thing to tell me that it was ready. So I'm going to add this to the stage, guys. I don't know. Let's see. I'm going to do this, and then I'm going to add this. So this is going to take me. So I'm going to talk to you about common law trusts, okay? So we're going to talk about the difference between common law trusts. And let me move this over so that I can have these screens. This one and this one. Okay. So welcome to the comprehensive presentation on common law trusts and the ultimate guide to privacy and asset protection. Today, we're going to delve into intricacies of the two trust structures and then explore their historical context, their legal foundations, and then practical applications for them. So Benjamin Franklin once said, "An investment in knowledge pays the best interest," even though he's kind of a thief. Anyways, no, I'm not going to get into the history of that. But so anyways, moving on to, let's see, here we go. Okay, so to begin, let's define what a trust is. A trust is a legal arrangement where one party, known as the trustee, actually holds property for the benefit of another party, the beneficiary. Okay, trusts are crucial for managing and protecting assets. That includes anything with a title, and ensuring privacy and planning estates. So trusts originated as a method for landowners to ensure their land and assets were managed and distributed according to their wishes, what they wanted when they passed, okay? Especially during times when they could not oversee them personally. The essential elements of a trust include the settlor who creates the trust, the trustee who manages the trust property, and the beneficiary who benefits from the trust. Okay, so trust can be categorized into various types, each serving different purposes. These include revocable and irrevocable trusts, living trusts, testamentary trusts, and more. So understanding the nuances of these types is essential for effective estate planning and asset protection. Okay, so as Anatole France noted, the law in its majestic equality forbids the rich and poor alike to sleep under bridges, beg in the streets, and steal bread. This highlights the importance of structured asset protection. Okay, so moving on, we are going to talk about the thing that just disappeared. For me, not for you guys. Okay. So common law trusts have their origins, and we are on slide 3. Okay, have their origins in medieval England, and they play a vital role in managing feudal estates. Okay, they have evolved significantly and influenced by notable legal figures and statutes. Okay, so we're going to explore the historical context and development. The common law trust's origin can be traced back to feudal system where land ownership and use were strictly regulated. Nobles and landowners needed a reliable method to manage estates, especially during extended absences due to military campaigns or political duties. Does that sound familiar, everyone? The development of common law trusts was significantly influenced by the need to manage and protect the land and other assets effectively. Okay, so they needed other methods to do this, to protect these assets that they had. This system provided a way to ensure that property was managed according to the owner's wishes, even if they weren't present to be there to oversee it. As Sir Edward Coke famously said, a man's home is his castle. Moving on, I'm going to show you this. The evolution of common law trust from medieval to early modern England was significantly influenced. Oops, I'm sorry about the picture there. Let me do this. There we go. Now you guys can see it. Sorry about that. I didn't even see that my ugly mug was there. So anyways, okay, the evolution of common law trust from the medieval to early modern English was influenced by legal figures like Sir Edward Coke. And I've talked about this in my trust classes, but the Statute of Uses in 1536 played a pivotal role in shaping the legal requirements for establishing a common law trust. The Statute of Uses was introduced to address issues arising from separation of legal and beneficial ownership of land. Okay, it separated the two ownerships. Okay, legal and beneficial ownership were two different things. By bringing these together, the statute aimed to prevent landowners from evading feudal dues and obligations. However, it also led to the development of more sophisticated trust structures to preserve the benefits of these separations. So the separations happened, but in anybody that basically what it was is everybody got separated. Anyone that figured out how to unseparate, or everyone got amalgamated, and anyone that figured out how to separate them and control them could do it. And that's really what it is. The titles are, they are not in your property. One of them is, but one of them isn't. Or maybe one of them isn't. Maybe none of them are. I don't know, depending on what you've done. So the history of trust is rich with legal battles and reforms. Lots of legal battles and reforms. The landmark case of Earl of Oxford case in 1615, it established precedents of equity over the common law and made sure that equitable principles win in cases of conflict, when there was a conflict. So any cases that involved equity, there's a no-brainer there, guys. Let's see, common law or the winner. I think bing, bing, bing. I think I've got mine figured out. And by the way, I forgot to do my Tito tribute. Here you go, Tito.
The following program contains mature content and is the truth.
Oops, let's do that again, Tito. You deserve better than that. Here you go.
The following program contains mature content and is the truth.
That's what I'm talking about.
No part herein is intended to be legal advice and is for entertainment purposes only. Audience discretion is advised.
Yes, audience, all of you. You all be audiences. Okay, thank you for being an audience. I appreciate audiences. So thank you guys, all of you. So the statute of uses was issued introduced, and it addressed issues arising from the separation of those titles. So common law trust is rich with legal battles and reforms. Again, the Earl of Oxford case made sure that equitable titles prevail. Like, duh, I'm going to go with equity. Equity follows the law. So there you go. So anybody says, well, the law is higher than equity. Well, equity follows the law, but it just so happens that it can bend it. And that's what we're looking to do. So moving on to the next slide is going to be a discussion on the common law. So creation of trusts in common law. Establishing a common law trust, it involves specific legal requirements. Historical statutes, like the statute of uses, have laid the foundation for these requirements. So you guys can find out in the statute of uses what, like, all the secured party creditor trusts, they are statute of uses because they're pure common law trusts. What I'm going to show you is why that is not the best thing you want. Okay, because it does some things, but it doesn't do what you want. Creating a common law trust it does require the clear declaration of trust. Okay, you have to identify trust property, you have to identify the trustee and the beneficiaries, and the settlor must have the grantor settlor must have the intention to create the trust. Like somebody can't say, oh, no, they did that. They gave me this to handle for them. And then they're like, wait, what you talking about, Willis? You know what I mean? Like, you can't just bring something up and say, hey, no, you can't steal somebody's clip and say, hey, they told me to take this clip and put it right there. After you got caught stealing it, you're like, make up something. No, that's not a trust. I'm sorry. That is actually the opposite of trust, and that thing just shot me. So creating a common law trust requires those characteristics, and one of the essential aspects of creating that trust is the transfer of legal title to the trust to the trustee. Okay, it's a conveyance of the legal title to the trustee, or transference of the legal title to the trustee. The transfer must be done according to legal requirements of the jurisdiction that you're in. In other words, if you're in a state that has a certain jurisdiction, you follow that jurisdiction. Okay, there is no federal jurisdiction for this. It is a state jurisdiction, because the states create these titles, right? Think about it. I want you to think hard. I'm not going to give you any more hints than that. Titles, what are we talking about? What is a title? A title is anything that says, well, certificate of title. Certificate, okay? Sir lies a lot. Okay, so you know what, Living Twins, I can take questions, absolutely. So what I'm going to do is I'm going to go through this, and then I'll leave you guys some room to ask whatever questions you want. And if for some reason you come back and you say, oh, you know what, I wish I had that question, you can always go on to one of the live streams that you're on and post the question, because I will go back through there and check them, and I will answer all of your questions, even if they're not today. Okay, so no worries. So the common law trust we're talking about, the transfer is done according to the legal requirements of that jurisdiction. So however it says that a conveyance of a title is done there is how you do it in your state. Okay, so that involves usually executing a deed or some other formal document, and the trustee then holds the property for the benefit of the beneficiaries, okay, according to the terms set out inside of the trust document. See, this is where people get so unbelievably confused, because you guys, like, you have these documents or you want to understand them, but you don't know what they do. And so you get this thing that is like a control board that you don't even know what it does. Like, oh, I don't even understand this. And so you have to learn the things that I'm giving you here right now and know them very, very well, because you have to be able to show someone else what has happened in a certain circumstance. Okay, the life of the law has not been logic, it has been experience. And that's Oliver Wendell Holmes Jr. All the people that have been experts in this trust field, okay, I'll tell you that. Like, anyone that is, you guys see on TV, like all of these guys, okay, I want to give you an example. Fauci, okay, one of the biggest people that no one likes, right? I don't know. I don't have anything against anybody other than, some of those words were not true at all. Okay. And even if they were acting, they put people in a lot of harm's way. So I'm not I don't provoke any sort of negative like that. You guys, there needs to be full disclosure on things. Many of the stuff that we're not privy to right now is because we weren't given the chance. It's not because you guys can't learn it. See, that's my thing. That's the reason I'm on this thing, okay? Because, this is the only reason I do this, is because I think that you guys deserved a better opportunity to take control of something that you could have as your own and you could be responsible for if you had more knowledge on what it was. And there's some of you that I know very, very well that I know you're responsible enough. I know you are. I just know you are. I've seen you handle other things. And it's not the same as handling other things. It's a little different, but it's just righteous. All of it comes down to it's just like fairness. You know what I mean? It's like, I don't know, man. Everything that I do, it's like, okay, how can this be so that it works out for both parties? Like, how could it be to where it's just not totally unfair? Some things, when you write an equitable contract, for example, I try to give so that you guys have a way, if something doesn't work out, well, you know what? Just come to me and let me know. That's just the way we do stuff. If you guys are not getting something that I'm teaching, then come to me and we'll work something out. What I usually do is I usually set up a private meeting so I can explain to you privately what something means if you don't understand it, something that I'm teaching to the students. So that's where the focus is, and that's where the energy goes, because I know if I give you guys the tools, you can figure the rest of this out. And I've seen some of you get really creative in your ways and what you're doing and some of the stuff you're doing. You're it's almost like you're feeling energy from a past. I don't know, man. You guys are just super creative, and I just can't, I don't know where some of this stuff comes from, some of these ideas, but they're really good ideas, and kudos to all of you for doing that and even starting to think on that. So in contemporary times, common law trusts are extensively used in estate planning and asset protection, and they offer significant flexibility and a lot of control over asset management. And they make them super popular because they're just pretty easy to do. And most common law trusts can be revocable or irrevocable, which means that, revocable trusts allow the settlor to maintain control over trust assets and to make changes as needed. So something like for cars or things that you're going to go through frequently, you would want a revocable trust for. Things that are going to be more permanent, if you don't ever plan on getting rid of it, would be irrevocable. Okay? The difference is an irrevocable trust, once established, generally, they can't be altered. Okay? They can under certain circumstances, but not generally. And they provide stronger protection against creditors and legal claims. Okay? So common law trusts are also used in various other contexts, like family trusts, charitable trusts, and business trusts. Each type of trust serves a specific purpose, and it offers different benefits. For example, family trusts are often used to manage and protect family assets. Whoa, imagine that. While charitable trusts are established to support philanthropic goals. Okay? Privacy is not something that I'm merely entitled to. It's an absolute prerequisite. And that's a quote from Marlon Brando. So let's move on here. Oh, you know what? I skipped this slide here. And you know what? Why are these look like? Oh, they don't. They're not. Okay. So yeah, that's what I just went through and did for you guys. Okay. So I'm going to show you the control and flexibility of common law trusts. Okay. So we're going to talk about that real quick. So common law trusts offer a degree of privacy, although some information may be subject to public record requirements. Okay. The balance of privacy and transparency is a key feature of common law trust. So some stuff, and I've shown some of you guys my common law trust that I have, and you can go look at it. It's public record, but it's like you got to keep a balance of what you want in there and what you don't. So just keep that in mind. The extent of privacy provided by a common law trust depends on the jurisdiction and specific terms of that trust. And while the trust document itself might be private, certain transactions or filings may be required to be made public, depending on what your local laws are. So that'll clear up a lot of things for a lot of people. It's jurisdiction based upon where you are. And it's not where your birth certificate is. If you happen to live in the same place where you were born, then yeah, cool. If not, then it's where you are, because you are a resident where you are. Okay, so we'll explain more of in that, because there's some clarifications you make, and I don't want people to get alarmed by the word resident or any of the terms domicile or any of those, because we're gonna clarify much of that. Privacy is a critical concern, though, for many individuals establishing the common law trust, and many of you might have one or have had one before. And by carefully drafting the document and selecting the right jurisdiction, it's possible that you can achieve a high level of confidentiality while complying with whatever the legal requirements are. Flexibility is the key to stability. And that's a quote from John Wooden. Okay, so moving on, we have common law trusts provide significant flexibility, okay, in management and amendments, so you can change them around. Trustees are granted discretionary powers. They can make a lot of decisions on their own, and they can adapt to different changing circumstances quickly. That's why they're very easy. This is a very simple type of trust, a common law trust. But you're going to see that there is a higher level of privacy that you're going to find. And this flexibility is particularly beneficial for estate planning. Okay, so common law trusts are good for estate planning. It allows for adjustments in response to changes in the law. It allows for tax regulation adjustments or even family circumstances. Trustees can make decisions that best serve the interest of the beneficiaries within the framework established by the trust, of course. And that's the whole key to all of this. It's whatever the trust says. Like, people don't say, well, you don't have jurisdiction. Okay, well, you shouldn't be saying you don't have jurisdiction. You should be saying who does have jurisdiction. So if you have jurisdiction, you shouldn't be telling somebody what they don't have. Do you get what I'm saying? So there's a lot of things in this that you will learn that along this journey, and this is what I teach in the classes, that where people will learn that, just saying things and comprehending them are very important. And there's always additional meanings to things that we're not taught. So the discretionary powers of trustees can include decisions in like investments. They do distributions. They do management of trust assets. They do assignments. They do discharges, all that stuff. It allows trustees to respond to changing economic conditions and the needs of the beneficiaries, ensuring that the trust remains effective over time. So the hardest thing in the world to understand is the income tax, and that's Albert Einstein's quote. Give me just a second to move on here. And I'm going to take a sip of my amazing tea. Cool. So while beneficial, common law trusts can be complex and costly to establish and maintain. And they also might face jurisdictional and enforcement issues, which can pose challenges to trustees and beneficiaries. So the complexity of common law trusts, they often require professional legal financial advice to ensure that they're properly established and administered. Additionally, differences in state and national laws can create challenges for trusts that span multiple jurisdictions. For example, a trust is established in one state may not be recognized or enforceable in another state or country. It can lead to legal disputes and additional costs, making it essential to carefully consider the jurisdiction when establishing a common law trust. Equity looks to the intent rather than the form, and that is a maxim. So moving on to the next slide for you guys. Equity trusts are grounded in fairness and differ from the common law trusts in several ways. Okay, let's explore the historical context and the guiding principles of equity trusts. So equity trusts emerged from the Court of Chancery, a court of equity in England that dealt with cases of fairness that were not adequately addressed by common law courts. These trusts emphasize the intent of the parties involved and seek to provide remedies that achieve just outcomes. You understand? The trust's emphasis on the intent of the parties involved. That's not what you guys have right now. Do you understand that? Okay. So when that changes, then you have stuff that is enforceable. Not only that, but the sooner you learn what I'm teaching you, the sooner you will be able to get remedy for that particular trust that we're talking about, that common law trust, because your only remedy to that is in equity as well. So the principles of equity focus on fairness, good faith, and the intent behind your actions. Intent. This contrasts with the rigid rules of common law, allowing equity trust to provide more flexible and fair outcomes in certain situations. He who comes into equity must come with clean hands. Okay, it just is what it is. I don't make up the rules. I just follow them. All right, equity trusts evolved from the Court of Chancery, influenced by figures like Lord Eldon. The maxim, he who comes into equity must come with clean hands, underscores the importance of fairness and integrity in these trusts. Okay, the Court of Chancery was established to address grievances that the common law courts could not resolve. Over time, it developed a body of principles and precedents that emphasize fairness, good faith, and the intent behind actions. The history of equity trusts includes notable cases and developments that have shaped modern trust law. For example, the case of Keach versus Stanford. I'll put myself back on there for you guys. On the case Keach versus Stanford, which is 1726, it established the principle that trustees must not profit from their positions, a fundamental aspect of a fiduciary duty. So it's not about a profit, it's about a compensation, right? Equity will not suffer a wrong to be without a remedy. Okay, so you don't get compensation. You don't get as such the same kind of reimbursement in trust. Okay, so let's move on to the next slide here, and I'm going to show you guys. Equity trusts are formed based on fiduciary duty and beneficiary rights. Okay, those two things are super important. Equity trusts are formed based on fiduciary duty and beneficiary rights. Okay, this in principle ensures that trusts are managed with the best interests of the beneficiaries in mind. The creation of an equity trust requires a clear intention to create a trust. A trustee who accepts the fiduciary responsibility and a defined beneficiary. The trust purpose must be lawful, obviously, and the trustee must manage the trust property with a high standard of care and loyalty. Not rocket science, brain science, folks, not rocket science. Equity trusts are often used in situations where flexibility and fairness are paramount. I mean, does that sound like that fits you guys? Flexibility and fairness, does that sound like a couple of good words for you? So if that is, then that's something that you ought to look into. For example, they're commonly used in family trusts where the needs of the beneficiaries may change over time, requiring flexible approach to asset management and distribution. To be left alone is the most precious thing one can ask for in the modern world, and that's Justice Louis Brandeis. And let's move on to the next slide. All right, so equity trusts offer enhanced privacy compared to common law trusts. This makes them an attractive option for individuals seeking to protect their personal information and assets. The privacy afforded by equity trusts comes from their nature as private agreements that do not require public registration or disclosure. This confidentiality can be crucial for high net worth individuals and families seeking to protect their wealth from public scrutiny. Okay, when you say high net worth, the tax allowance I showed you guys for 2024 was $12.9 million. So that's what you should be claiming as far as if you are in the proper taxing bracket. So it's $12.9 million. So you should be getting a refund or you should be getting credit at least. So anyway, yeah, that's kind of what we're showing you guys is the privacy that's afforded to equity trust comes from their nature as private agreements. Okay. They are private agreements. Article 1, Section 10. Nobody can inhibit your ability to contract with anyone else. Okay. And they do not require public registration, nor do they require any disclosure. Okay. This confidentiality can be crucial for you guys because, I mean, when you're doing claims like $12.9 million a year, that's pretty high net worth, right? And you want to seek protection of your wealth from public scrutiny. You don't want to be like people knowing what you're getting. And I mean, that's how these other folks are doing it that you guys see and watch and many of you look up to, in the public eye. But privacy in the equity trust is most often achieved through the careful drafting of the documents and selecting a jurisdiction that provides the strong privacy protections. And it ensures that the details of the trust and its assets remain confidential. The protection of private property is indispensable to the development of civilization. And that's Ludwig von Mises. So moving on to the next. Equity trusts provide robust asset protection mechanisms, shielding assets from creditors and legal claims. And this level of protection is crucial for preserving wealth and ensuring financial stability. Equity trusts can include specific provisions that limit the ability of creditors to reach the trust assets. And these protections are particularly valuable in situations that involve business risks, professional liability, or family disputes. Do you see how this is becoming more of a personal thing instead of like a public commercial thing? And that's the difference between the common law and the equitable trust. Asset protection in equity trust is achieved through various legal mechanisms like spendthrift provisions. Does that sound familiar? Which prevent beneficiaries from transferring their interest in the trust to creditors. This ensures that trust assets are preserved for the intended beneficiaries. Intended, there's the word again. Accountability is the glue that ties commitment to the result, and that's Bob Proctor. So moving on. Okay, trustees of equity trusts are bound by fiduciary duties and can be held accountable for breaches. And this ensures that trustees act in the best interests of the beneficiaries and uphold the trust's integrity. The fiduciary duties of trustees include the duty of loyalty, the duty of care, the duty to act impartially. Those are the primary duties. These duties require trustees to manage the trust property prudently, good judgment, avoid conflicts of interest, and to treat all beneficiaries fairly. So, trustee accountability is a critical aspect of equity trust, providing beneficiaries with the assurance that the interests are being protected. If you don't know what the interests are, you can't protect somebody. If a trustee breaches their fiduciary duties, beneficiaries have legal recourse to seek remedies, ensuring the trust operates as intended. A comprehensive analysis provides a clearer perspective. And that's a quote. I don't know who that's by, so I don't take any credit for it, but it's cool. Okay, so a comparative analysis of privacy features highlights the differences and benefits of each trust type. Okay. Understanding the differences can help you choose the right trust structure for whatever your needs are. In common law trusts, some information may be publicly accessible, whereas equity trusts often provide greater confidentiality. The choice between these trusts depends on like the specific privacy needs and the goals of the settler. So privacy is a significant consideration for many individuals establishing trust. By comparing the privacy features of common law and equity, it's possible to make informed decisions that align with your objectives and make sure that your assets are protected. So equity does not act for its sake, but to do practical justice. Okay, So questions. We have a question. Can a trust be a beneficiary? Can a trust be a trust can receive benefits? Yeah. So I mean, in a way, it can. It can. You can say, I want all of the proceeds of this business to be a donation to this trust, and it can be a beneficiary of those proceeds from another place. So if you give a trust something, it's the beneficiary of that. If so, how would the grantor stipulate the trust? Well, the grantor would stipulate that when they write the trust, they're saying, I'm granting this trust for the purpose of providing whatever comes out of it to this other trust as a beneficiary. Just stipulate it. So the trustee doesn't breach the trust. Well, okay, so now you're asking, like, okay, how would a grantor stipulate a trust so the trustee doesn't breach a trust when the trust is a beneficiary? Well, the grantor of one trust would stipulate to the trustee that he wants the proceeds of all that trust to go to the other trust. Then that trustee would make sure that those funds were to go to the beneficiary, whoever the grantor assigned or whoever the settlor assigned as the beneficiary, which was the other trust that you're talking about that's receiving it. Then when that other one receives it, they know where it comes from, but nobody's asking questions because they've got a copy of the trust that says it's supposed to go where it's supposed to go. And that's just how it flows. Everything's in writing. Okay, so good question, though. So equity trusts offer a lot of advantages over the common law trusts, including better privacy, asset protection, and flexibility. And they're designed to provide practical justice and meet the unique needs of each beneficiary. You guys can't have, you can't see the problem. The reason that we're in the problems is because we have a cookie cutter stuff. Like, okay, you are this, so you go over here. You are this. It's not like a unique thing. When you sit down and say, oh my gosh, what's ailing you? Your hands hurt. Oh, no, when you go in and, nope, you're a baby that got dropped off without instructions. You go right over here, and that's it. That's it. That's the end of it. It's just, that is what the equity trusts are different on. The flexibility and fairness of equity trusts make them an ideal choice for you guys in seeking to protect assets and ensure that your wish is honored. And they provide a higher degree of control, okay? Not that we're control freaks, but we're control freaks. They provide a higher degree of control for all of us control freaks that are not control freaks, if you ask us, and can be tailored to address specific legal and financial circumstances for non-control freaks, for the control freaks that are freaking control freaks. Okay? Equity trusts are particularly beneficial in situations where needs of beneficiaries are likely to change over time. So by providing flexible framework that can adapt to changing circumstances, equity trusts offer a practical solution for long-term asset management and protection. And Benjamin Franklin said, an investment in knowledge pays the best interest again. Funny. He a funny guy. I like him. His quotes anyways, or wherever they get these quotes from. All right. So in conclusion, both common law and equity trusts, they have their unique strengths and applications. Okay. However, equity trusts can provide superior privacy, asset protection, and flexibility. And I thank you guys for your attention. I want to open up and I'll answer any questions that you might have. And then, I don't know. Who knows? Who knows what happens? Maybe we just all go out to the lake and jump in the water and cool off. I don't know where you guys are. But, it's not happening today. It's a little too late. And I'll tell you a story before, I don't see any questions up here right now, but I will accept questions. And I'll just tell you a little story in the meantime. Today I went to the dog park and took my dog again. And it was just a weird thing that happened today. By the way, we're not streaming to the website right now. So the key didn't work. So that will have to be reposted again at another time. Went to the dog park and I took my dog and go ahead, Prairie Living Twins, go ahead and you can just post your question and I'll answer it. Just type it in and I can see when you post it. But I took my dog to the dog park, and my dog is just very friendly. He's still a puppy, and he's a big puppy. As many of you know, he's a big dude, but he gets like excited and plays and stuff. Well, this one dog just like went and picked on him, and I was across like the way, and this dog pinned him down and had him pinned down, and he's a puppy, and he's yelping like, let me up, let me up. And this other dog was just on top of him, and this girl that owned this dog was standing there just watching as if, yeah, I'm just going to let him go. And I ran over there and I dropped everything that I had in my hands, and I picked up her dog and I threw her dog, not throw it, like throw it. I tossed her dog out of the way, and like, well, I babied my dog after that. I'm not going to lie, because like he was yelping. He's sitting there yelping, and he was still like traumatized. I just wish that people would, like, I don't know what, and I thought about it after. I thought, you know what, that girl to do that must, like, I don't know, like, you're either getting some sort of gratification from watching that somehow, some way, which is sick to me, or you don't get it. And either way, you need more training before you should be having a dog. So you need to go to people training and learn a little bit of etiquette, people, okay, before you start doing that and bringing your dogs and not taking care of them. Okay, so what happens if a trustee refuses to give the beneficiary assets? If a trustee refuses to give a beneficiary assets, then the trustee is either, one, just saying, forget it, I don't want to do my job, or they are not giving something because they have a reason, which usually it means that it's still in a trust situation where they can't give it up, and so they don't. And so we think that they're refusing when they're actually just following the real trust, and we don't have the authority. We haven't shown them authority to do anything. So, and not only that, but, everything usually says you're not a beneficiary. So that's the problem. That's the whole problem, is you created another trust that's something different. Okay. 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 All right. So, okay. So Prairie Living Twins, you have like a bunch of stuff that you can still do. Okay. So your mortgage company, after you, but it's about a W-4. I took the class before I put in my W-4 sandwich. I got a letter from a mortgage company saying that your deed was paid in full. Okay, so they created a new account. Okay, so you're gonna need to get in touch with somebody here, because that is like kind of a complicated situation. But you need to do a lot of different steps because it's a mortgage situation. I'm actually helping someone that is in a situation just like yours, where it's just gotten complicated, and now what they did is they had her sign another deed or sign another mortgage, and it's paid off. She has that paid off paper in her hands. And so you're going to need to follow through with that. Just reach out if you can. Go to the Telegram group, Lone Wolf Pack, or you can just reach out, and JC, who's Exclusive Equity, you can write a message to her, and she will get you set up. Okay. Yeah, we'll get you a one-on-one in Telegram, of course. And we can get you some help with that, because you just need to organize some paperwork and then get your paperwork off. Now, this is like, I want everyone to understand that this is one of those things, and these are one of those situations where it's a record, okay? In the common law, it says it happened. If you go and make an agreement like that, it just says, oh, common law says, oh, no, it happened. It's not a special situation where you signed it and you're like, oh, wait, maybe I did that wrong. That's not a common law thing. Common law is not going to fix that I did that wrong thing, where you pull it back and you go, uh-oh, I don't feel right about this. Common law doesn't fix that, guys and gals. Okay? That's why you need to get into equity. And equity will, fix things, but you got to know what you're doing in this. And there's not many people that really understand and know what's happened. A lot of the people are going in common law, in everything in common law, and bringing stuff into common law is brokering your own estate or your own property out for someone to make a decision on your own life. It's like literally saying, I don't know how to make this decision, so do it for me. All of your decisions that we all have are very simple. I mean, seriously, our decisions like, I want to get up and I want to have a yogurt for breakfast. I mean, if that's what you want, or I want to have maybe a I don't know, a smoothie for breakfast, or I want to have, tea for breakfast, whatever you like to have for breakfast. Who can tell you that you can't? Well, right now, nobody can tell you that you can't. You just go and do what you want to do, right? But when it comes to when laws get more stringent, like, for example, if you want to continue to stay employed here, you need to go and have this thing done or this procedure done or something done, right? Then that is a contingent account now. So it went from an account that said, oh, no, you don't ever need to do that, to, hey, now we want to give you a contingency on your employment. Someone says, hey, you know what? I would like to offer you a lifetime membership to our church. And then 6 months later, it says, oh, you know what? That lifetime membership we offered you, you still got the lifetime membership, but now it's $100 a year. Isn't that nice of them to do that? It's now a free lifetime membership, but it's $100 a year to join. So you're going to have to pay up. And there's a lot of places that have done that, converted like that, and do crazy things like that. So when you learn that you guys can create anything you want, and you've been told that there's only one set of tracks that gets you where you're going. And that set of tracks is what you need to take to succeed. And that is a misconception. That is misleading information. That's not true. And you guys, because we believe it and because we put it into a programming, we just keep going by that. And we don't need to go by that thing. We need to realize that we have many other options. Many, not M-I-N-I, M-A-N-Y. We have a lot of other options. And as soon as we want to take advantage of those options, we can. But how does one take advantage of something that one doesn't know exists? And when there's people that are not telling you for reasons that could be used to capitalize on your lack of knowledge, because if you don't know to go get something or to do something, then you're not going to be you're not going to be aware of what's going on. So you're going to be looking in different directions, and you're going to be trying to do other things that are not conducive towards what sort of resolution you're looking for. So I have so Just Prairie Living Twins, I just want to let you know, I have different staff now. I don't have the same people that are with me. So no, the people that were with me before are no longer here. However, I do have an amazing group of, let's see, 1, 2, 3, 4, 5, 6, 5 or 6 admins that are helping. So you can reach out to Divine9 in Telegram. That's JC. Or JC is Exclusive Equity in the comments here where you're commenting now. Or you can go to lonewolfpack.net. You could schedule a meeting there, or you can go to the Telegram, which is Lone Wolf Pack in Telegram. So, and it's got the same kind of colors as here, right? Same kind of colors up here as the Lone Wolf Pack, and the same as this in this display and everything you guys see here. So all that stuff is good, and we will help you guys get everything like on track where you need it. I don't have anything else, guys. So I wanted to be clear on what I'm presenting to you today. I wanted to show you the difference because I did tell the class that I would go over the difference between common law and exclusive equitable trusts. And I have a class that's going to be starting up for those of you that are interested in creating your own private equitable trust. You will be given all of the steps on how to do it. And I will be teaching a class through 8 different sessions privately with you. If you would like to join, you just get in touch with lonewolfpack.net, or which is up on the or down on the screen right here. Okay, or you can go to the Telegram channel, or you can post a comment in here, and we'll get back with you guys on your comments. So I appreciate you guys for coming out today. Thank you so much for being a part of this and learning on more of things that are going to help you to break free from, control, things that have controlled me in the past and have controlled you in the past or currently controlling you. So anyways, you guys have an amazing day. I appreciate you so much. With that, I send you good energy, and with that, I yield.